What would be some reasons that an applicant attorney would schedule a deposition? Well, let's go through 10 reasons. Reason number 1, just as we said regarding the defense attorney, an applicant attorney may hope that they can get rid of an unfavorable QME report by getting rid of the QME by making it difficult or making the QME, or finding out if the QME is not able to schedule the deposition within 120 days. If the QME evaluator is not available within 120 days, well, that is grounds for having the QME evaluator discharged from the case. So that can go both ways. Both applicant and defense attorneys can use that as a strategy. Reason number 2 is to resolve an outstanding issue regarding treatment needs. Now, as this is being recorded, it is possible that having the QME evaluator discuss treatment needs could be a thing of the past. And because as this is being recorded, we are pending the passage of Senate Bill 863. It has been approved by all houses, but has not yet been signed by the governor as this is being recorded. So it may be that QME evaluators will be discussing treatment needs less and less, although at the time of this recording, QMEs are still involved with handling disputes over treatment issues, and that's why this is given here as one of the reasons. Reason number 3 that an applicant attorney would call for a deposition is because there's a dispute about the permanent impairment rating. And what could that dispute be? That the permanent impairment rating is too high? Well, probably not. It's probably that there's a dispute that permanent impairment rating is too low. Now, there's an infinite number of possibilities and arguments that can arise, and the scope of every possible argument regarding permanent impairment is beyond the scope of this program. But we will mention a couple of different possible challenges to the doctor's permanent impairment rating as we go through our case examples later in the program. And in line with reason number 3, that there's a dispute about the permanent impairment rating, it may be that the applicant attorney simply wants to request that the QME evaluator address the Alvarez-Guzman 2 line of cases, and perhaps convince the doctor that perhaps an alternative permanent impairment rating under Alvarez-Guzman 2 is more appropriate and is a more accurate description of the permanent impairment rating than is a permanent impairment rating under the strict application of the AMA guides. So if you have not offered both a strict permanent impairment rating and an alternative permanent impairment rating, be prepared to be challenged on that, because that is now one of our edicts. That is, we are at least to address the possibility that an alternative rating could more accurately describe the permanent impairment. And if you don't think that an alternative rating does better or more accurately describe the permanent impairment, that's fine, that's okay. You simply need to state that, which shows all parties that you at least considered the possibility that an alternative rating could apply, but in your opinion you considered all possibilities and you don't. And that's perfectly fine as long as you address it that way. Reason number 4 that an applicant attorney may call for a deposition is for a dispute about apportionment. And again, there's probably an infinite number of arguments regarding your opinion on apportionment. We will discuss several of those here, several of the more common and more important ones, but again, just remember that this is an area where many curveballs can come at you. The infinite number of arguments to either increase the percentage of apportionment or to decrease your percentages of apportionment. Let's just leave it at that for right now. With regards to apportionment, and you will be deposed on your apportionment determination, because both parties are going to have some say as to the amount of the permanent impairment that's actually directly due to the industrial injury. So let's talk a little bit about apportionment before we finish up with the 10 reasons. Now, apportionment is described in Labor Codes 4663 and 4664. I should say proper apportionment is described in those two codes. And it's important that you're familiar with these codes. And I'm going to recommend that you become fluent in citing these codes. And there was a time that I was not fluent in citing these codes, and I'll give you an example a little bit later on about that. But these come up so often in deposition that I recommend that you be fluent. If you are fluent and can cite these codes, it is most impressive and most persuasive. So let's go over these here. Labor Code 4663 states, quote, "A physician shall make an apportionment determination by finding what approximate percentage of the permanent disability was caused by the direct result of an injury arising out of and occurring in the course of employment, and what approximate percentage of the permanent disability was caused by other factors both before and subsequent to the industrial injury, including prior industrial injuries," unquote. So let's summarize that. Your job as a physician is to make an apportionment determination by using approximate percentages. Approximate percentages. What does the word approximate mean? Does it mean exact? It does not mean exact. It means approximate. In fact, there is no way that you can be exact in many of your apportionment determinations, but that's okay. The Labor Code 4663 supports approximate percentages. So you're to make a determination as to what is the approximate percentage of the permanent disability that's caused by the injury, and what is the approximate percentage that's caused by quote-unquote other factors, and we'll just call them other factors. Other factors both before the injury and after the injury, including any prior industrial injury. So that's 4663, and you should be pretty much fluent with that. And you should be comfortable with that. Comfortable with the fact that when you render your apportionment determination, you can be approximate. You don't have to be exact. There's no pressure to come up with an exact, written in stone, bona fide, verified, till death do us part number. In fact, that's largely impossible, but that's okay. Your apportionment determination will be upheld even if it's only approximate, as long as you explain how and why you arrived at your approximate percentages. And we'll talk about some hows and whys as we go along here. Labor Code 4664 is divided into two sections. There's an A and a B. Section A says that the employer shall only be liable for the percentage of permanent disability directly caused by the injury arising out of and occurring in the course of employment. Section B says, if the applicant has received a prior award of permanent disability, it shall be conclusively presumed that the prior permanent disability exists at the time of any subsequent industrial injury. This presumption is a presumption affecting the burden of proof. So this is an interesting labor code. This, of course, favors the defense, because it says in Section A that the employer or the insurance company shall only be liable for the percentage of permanent disability directly caused by the injury. not for anything else. Only the percentage that's directly caused by the injury. The insurance company doesn't want to pay, and it's not obligated to pay, and by law is not required to pay for anything above and beyond that percentage, that approximate percentage that you provide with your apportionment determination that's caused as a direct result of the industrial injury. And then Section B is also a defense or insurance company oriented code. It says that if the applicant has received a prior award of permanent disability, that prior award exists even through today. It exists at the time of any subsequent industrial injury. It exists at the time that you examine the injured worker. It exists at the time that the injured worker is declared to be permanent and stationary. And it exists into perpetuity, forever and ever. And that's a new addition to the code that came in with Senate Bill 899. It used to be where an injured worker could demonstrate that he had completely rehabilitated himself from the effects of a prior permanent disability. And in which case, if the injured worker was completely rehabilitated, then at the time of the industrial injury, they were back to ground zero, presumably 0% permanently disabled, and then any subsequent permanent disability could be attributed to the new industrial injury. Well, that went away in 2004 with the passage of Senate Bill 899, and it's now conclusively presumed that any prior permanent disability exists even through the date that you examine your injured worker. So you need to be familiar with those two codes, and don't be surprised if you are quizzed, even quizzed on those codes. And I've been quizzed on those codes in the past, and I've been caught a little bit off guard by those codes in the past, and so I'm really encouraging you to read those. Make sure that you understand each and every clause of those, because they will come up time and time again, and you will be required to defend your opinion when you make an apportionment determination. Now, apportionment issues and the burdens of apportionment and what constitutes valid apportionment was definitively addressed and established by the Escobedo case. And we're going to review the Escobedo case here a little bit in this program, and also I've included the entire Escobedo case in your handout materials. And you'll need to read the case in its entirety, because several of your examination questions are going to come directly out of the Escobedo case. And many times when you get a cover letter from either the defense attorney or applicant attorney, when they ask you for your apportionment determination, they reference the Escobedo case, and they'll say something like, please render an apportionment determination consistent with Escobedo, and you'll see the word Escobedo like in italics. Well, Escobedo refers to an injured worker, Marlene Escobedo, and she was working at the time for Marshall's retail store, which is a clothing store, and she had some knee injuries, and she had some permanent impairment resulting from those injuries to both knees. And the doctor rendered an opinion on apportionment, and his opinion got challenged. And so what constitutes valid apportionment was definitively addressed by the Escobedo court. And some of the conclusions from the Escobedo case we're going to go over here now. And these, you need to keep these in mind, since these are the major money issues for which you may be deposed. Okay, number one, and that is, apportionment shall be based on the causation of the permanent disability, not the causation of injury. So, doctors, this is the causation section of your permanent impairment report. When your injured worker is permanent and stationary, you need to have a separate section in your report entitled the causation/apportionment of the permanent impairment. And it used to be where we would talk about causation of the injury and all these various factors that may either have caused the injury or contributed to the injury, or maybe contributed to a worse injury than we otherwise would expect. That is not valid apportionment to apportion to the causation of the injury. With valid apportionment following Escobedo, we're concerned only with the causation of the permanent disability. We're not concerned with the causation of injury, and sometimes those things are completely different. Sometimes they're the same, or sometimes they're related, but sometimes they're completely different. And following Escobedo, valid apportionment is based on causation only of the permanent disability, and we'll discuss that a little bit more. Now, interestingly, the applicant, meaning the injured worker, meaning the applicant attorney, the applicant has the burden of establishing the percentage of disability directly caused by the industrial injury, and the defendant, meaning the insurance company or the defense attorney, they have the opposite burden. They have the burden of establishing the percentage of disability which is caused by other factors. And if we go back just a couple minutes, we described what at least some of those other factors were. That was described in Labor Code 4663. It said what approximate percentage of the permanent disability was caused by other factors, both before and subsequent to the industrial injury, including prior industrial injuries. So other factors could be things that happened before the industrial injury in question, could be things that happened after the industrial injury in question, like, for example, the person was involved in a car accident 6 months after the industrial injury. That could be another factor. Prior industrial injuries could be considered other factors, and it's the defendant that has the burden of establishing the percentage of disability caused by other factors, while the applicant has the burden of establishing the percentage of disability directly caused by the industrial injury. So let's think about this. We're discussing reasons why an applicant attorney would call a doctor for deposition. And we said that apportionment is one of the major financial drivers of the case. And in your QME report, you've rendered an opinion on the causation and the apportionment of the permanent impairment. And let's just say you've rendered opinions that 50% is directly due to the industrial injury and 50% is caused by other factors. The applicant has the burden to establish that at least the 50% that you're reporting, and perhaps even more, and they're going to argue for more, and they're going to bring you to deposition to try and get that percentage up, the percentage caused by the industrial injury up. And you can anticipate this in advance. This is the purpose of this program, is to help you anticipate in advance some of the issues that you're going to be confronted with. And one of the issues that the applicant attorney is going to confront you with is your percentage of apportionment that you're attributing directly to the industrial injury. They're going to try and get that up. Now, on the other hand, the defendant, they are going to try and get you to get up the percentage of permanent impairment that you ascribe to the other factors. Prior injuries, prior industrial injuries, subsequent auto accidents, subsequent slip and falls, pre-existing conditions, pre-existing asymptomatic conditions, degenerative changes, all manner of other things. So knowing this, This allows you to predict in advance before the deposition, and allows you to prepare before the deposition your argument regarding your apportionment determination. Be prepared to support your apportionment determination knowing that the applicant is going to try and increase the percentage directly caused by the injury, and the defendant is going to try and increase the percentage due to other factors. Very interesting. Now, a little bit of groundwork here. We're going to be discussing some more major points of the Escobedo case. One of the other major, profound, and practice-changing tenets from the Escobedo case has to do with what's called substantial medical evidence, and this is important also in deposition. The Escobedo case stated that medical reports that address apportionment must qualify as substantial medical evidence. Well, what is substantial medical evidence? In other words, what makes your opinion substantial? What makes it substantial medical evidence? Well, number one, it must be, meaning your opinion must be based on relevant fact. What's the opposite of relevant fact? Irrelevant facts, unrelated facts. It must be based on relevant fact. Number two, it must be based on reasonable medical probability. Reasonable medical probability. That means more likely than not. 51% or greater. It's medically probable. It's more likely than not medically that XYZ, whatever your opinion is. It must be reasonably medically probable. More likely than not. It must be, number three, it must be based on clearly stated reasoning that is not merely conclusory. Let's say that again. It must be based on clearly stated reasoning that is not merely conclusory. What is conclusory? Conclusory means you've simply rendered the conclusion. You've stated the conclusion without offering the reasoning. For example, here's a conclusory statement. The Mrs. Jones permanent impairment is due 40% to the industrial injury and 60% to pre-existing degenerative change. Period. That is a conclusory statement. That does not qualify as substantial medical evidence because it does not include your clearly stated reasoning why you arrived at 40% for the industrial injury and 60% due to other factors. Mere conclusions will not be upheld as substantial medical evidence. Number 4 criteria for substantial medical evidence: the apportionment opinion must describe in detail the exact disability that is being apportioned. The exact disability that is being apportioned. And this is an interesting topic that we don't have a lot of time to go into here. Maybe we'll make this the topic of another program. But when you render your apportionment opinion, make sure that you're describing what is the exact disability that you're apportioning. For example, I can think of an example here off the top of my head. If you had an injured worker that had a shoulder injury, and that shoulder injury required a surgical procedure, and let's say, just for purposes of illustration, that he had had a prior surgical procedure maybe 10 years ago, but this particular new surgical procedure involves an arthroscopic Mumford procedure. And for those of you not familiar with the Mumford procedure involves a resection of the distal clavicle, typically about a centimeter and a half of the distal clavicle. So when it comes time to render permanent impairment decisions and render an opinion on the apportionment of the permanent impairment, when you provide for permanent impairment due to resection of the distal clavicle, that is due 100% to the surgical procedure. Resection of the distal clavicle has nothing to do with the prior injury to the shoulder. It has only to do with the resection of the distal clavicle, and the resection of the distal clavicle was due 100% to the surgical procedure that they just underwent, and that surgical procedure was due to the industrial injury. So I just cite this here as an example of how you must describe in detail the disability that you're being apportioned. Now, with the same injured worker and the same injury and the same surgery, you may find that following the second surgery, when you finally examine this person, that they have a loss of range of motion. That is a different impairment than is impairment due to resection of the distal clavicle. And your apportionment opinion regarding the loss of range of motion of the shoulder could be completely different from your apportionment opinion related to the resection of the distal clavicle. You may find that some of the loss of range of motion pre-existed even the second surgery, or even pre-existed the industrial injury, in which case there may be some apportionment for loss of range of motion, whereas there would be no apportionment for the resection of the distal clavicle. So this is just an example, and I give that to you just to illustrate that in order for your opinion on apportionment to be substantial medical evidence, you need to be very clear, and you need to discuss each disability that you're apportioning, and you have to have clearly stated reasoning in support of each of your opinions. So what about degenerative changes? What about asymptomatic pre-existing conditions? I go into this a little bit here in the discussion of the 10 reasons that an applicant attorney would request a deposition, because really, as far as the medical legal issues go, permanent impairment and apportionment really are the meat and potatoes of what you're at a deposition to discuss, because those are the two financial drivers to the case. And you can anticipate in advance that if you render an apportionment opinion, you're going to be challenged on it, because the applicant attorney is going to want to increase the percentage impairment due to the industrial injury. The defense attorney is going to want to decrease the amount due to the industrial injury. So you can anticipate this in advance. And so let's say, for example, you have an injured worker and you've rendered an apportionment determination, and you said that some of the permanent impairment is due to degenerative changes. Or instead of degenerative changes, let's say we found some sort of a pre-existing condition that was asymptomatic. Maybe it was a spinal anomaly. Maybe it was an anomaly of the wrist, such as ulnar variance, or some other asymptomatic pre-existing condition. Maybe they have a limbus vertebrae in the spine. Maybe they have a block vertebra in the cervical spine. Maybe they have a lumbosacral transitional vertebra. I don't know, I'm making this up, but these are all what we would call asymptomatic pre-existing conditions. So I just want to give you an idea of some questions that you can anticipate that one or the other party may throw at you in order to get you to either increase or decrease your percentages due either to the injury or due to other factors. And here's a question that actually happened to me, and this is why I stated what I said earlier. And that is, the question is, one of the attorneys asked me, they said, "Doctor, what is your understanding of Labor Code 4663? I mean, that was like his first question. "Doctor, what is your understanding of Labor Code 4663? And I thought in my mind real quick, well, I remember 4663. I can't quote 4663, but I know right where in my report it is, and it's in the apportionment section of my report, and I use it all the time, but I couldn't quote it. And I couldn't remember the major premises of it right off the top of my head. I mean, if I looked at it, I could, and I use it all the time, but I wasn't so familiar with it that I could quote it. And I'm recommending that now I can quote it, and I'm recommending that you have equal facility with it, because it shows up so often, and you'll have to deal with it so much. So you might as well demonstrate your facility with it. So I simply answered, well, geez, I don't know. Can you read it to me? I can't quote it off the top of my head, so can you read it to me? And so he did, and I remembered, oh yeah, that's Labor Code 4663. So once my understanding and refamiliarization with it was established, he then asked me, well, how does Labor Code 4663 apply in this case? A very open-ended question. And he was challenging my opinion on apportionment by taking me all the way back sort of to the fundamentals, to the beginning, with both of us establishing a common understanding between the two of us of 4663. Thereafter, we could then have meaningful discussion about my apportionment opinion. Okay, so the point is, be familiar with 4663. Now, another question with regards to degenerative changes or pre-existing conditions, whatever those may be, here's a question that you're going to deal with to challenge, to handle challenges to your apportionment opinions. Doctor, with regard to degenerative changes, or it could be with regards to pre-existing conditions, or it could be with regard to that block vertebra, whatever it is, fill in the blank. With regard to degenerative changes, what facts do you rely on to conclude that the degenerative changes or the block vertebra is causing impairment? Let's say that again. With regard, let's talk about block vertebra. With regard to the block vertebra, doctor, what facts do you rely on to conclude that the block vertebra is causing impairment? And by impairment, we mean any kind of functional loss of the cervical spine, or interference with activities of daily living. That's what we mean when we talk about impairment. So, doctor, with regards to the block vertebra, what facts do you rely on to conclude that the block vertebra is causing impairment? This is an applicant attorney question when the applicant attorney sees in your report that you have provided some apportionment to this pre-existing condition of a block vertebra. He wants to know, what facts do you rely on to conclude that 40% of the current permanent impairment is due to the block vertebra? So you can anticipate this line of questioning in advance. When you render an apportionment opinion, you can you need to be prepared to be able to support that opinion with questions like this. And they come in all manner of different phraseologies. These challenges to your apportionment determination. Another question that might throw you a curveball, and it's kind of the same line of reasoning. Doctor, what evidence do you have to indicate that the block vertebra was causing impairment prior to the industrial injury? Well, what do you mean prior to the industrial injury? We don't have any evidence at all that it was causing impairment prior to the industrial injury. In fact, it was an asymptomatic pre-existing condition. It wasn't causing any functional loss or interference with activities of daily living at all prior to the industrial injury. Well, doctor, how then does it affect your apportionment opinion when we know in fact that the blocked vertebra was not causing any impairment prior to the industrial injury? In which case you'll have to admit, well, indeed, maybe this blocked vertebra is not causing any impairment now. If it wasn't causing any impairment prior, maybe it's not causing any impairment now, even though there was the industrial injury. Now, this is just an example. You may opine that this blocked vertebra is causing impairment, even though prior to the industrial injury it was completely asymptomatic, and that's okay as long as you can substantiate your opinion and make it substantial medical evidence. But just be prepared for this line of reasoning, and this particular question would be an applicant attorney question, trying simply to increase the amount of percentage of permanent impairment directly caused by the industrial injury, and thereby minimizing the amount of permanent impairment related to other factors such as the blocked vertebra. A couple more apportionment questions and then we'll move on. I've had this question before, and in the early days it was a bit of a curveball, but it's not now. Doctor, what is the difference between cause of injury versus cause of disability? And make sure that you fashion your apportionment opinions strictly related to the cause of the disability. Finally, question, Doctor, would you agree that it would be speculative? Speculative, that's a key word. Doctor, would you agree that it would be speculative to state with certainty when, or even if ever, Mr. Jones would have suffered symptoms or impairment from the blocked vertebra? Would you agree that it would be speculative to state with certainty when, or even if ever, Mr. Jones would have suffered symptoms or impairment from the blocked vertebra? Yes, it would be speculative. We have no way of knowing when or even if ever Mr. Jones will have symptoms or impairment from the blocked vertebra. It would be speculative. Maybe my apportionment percentages need some modification. May I address this in a supplemental report? Okay, so I simply give these to you as examples of how your apportionment determination could be challenged, and I give you several questions, and we dwell on this shortly here because apportionment is one of the major issues upon which you will be deposed. Okay, what are some of the other reasons? We're on the 10 reasons that an applicant attorney would request a deposition, and that was all the way through reason number 5 was to request clarification on your apportionment opinion. That was number 4. Number 5 would be to request injuries, and I put injuries in quotes, request for injuries that might be outside the scope of your particular medical specialty. In other words, to determine whether or not you will be making consultation referrals to other specialists or the appropriate specialists, such as perhaps maybe a neurologist, maybe a medical orthopedist, maybe a pain management specialist, maybe a psychologist, maybe a urologist, maybe for a sleep study. Now, as this program is being recorded, we are pending the passage of Senate Bill 863. Senate Bill 863 may do away with referrals for psychology, urology, and sleep, so-called psych, sex, and sleep as compensable consequence injuries. However, as of this recording, those referrals are still permitted. However, it's likely that those will go away, but referrals to appropriate specialists will still be required. And this could be a major endeavor for the applicant attorney, is to make sure that their injured worker gets all the medical treatment that their condition warrants. And also one of the purposes for seeking outside consultations with specialists is simply to increase permanent impairment ratings. And so certainly with regards to psych, sex, and sleep, those gave us, and I use the word gave because I use the past tense because it appears that consultations for psych, sex, and sleep are going to be gone. But those consultations gave added permanent impairments in the form of what were called add-ons, and strictly used to increase the permanent impairment ratings. So applicant attorneys still may request for consultations if those haven't already been made. So because this is such an important area for the applicant attorneys, let's briefly discuss some of the labor codes and procedures involved with making consultations to the appropriate specialists. Now, consultations and the procedures that govern consultations are described in the QME regulations, Title 8, CCR Division 1, Chapter 1, Article 1, Section 32, beginning with letter C. Let's go through these. It says, for injuries occurring on or after 1/1/94, which is certainly now, a QME may obtain a consultation from any physician as reasonable and necessary pursuant to Labor Code Section 4064A, which I'll go over 4064A in just a second. But notice it says here from any physician. Does not have to be a QME evaluator. Can be any physician. Primary care physician, endocrinologist, hospital-based specialist. Does not necessarily have to be a QME physician. As reasonable and necessary pursuant to Labor Code Section 4064A. So let's read 4064A. 4064A says the employer shall be liable for the cost of each reasonable and necessary comprehensive medical legal evaluation obtained by the employee pursuant to Sections 4060, 4061, and 4062. Those are codes that are involved with resolving disputes. Each comprehensive medical legal evaluation shall address all contested medical issues arising from all injuries reported on one or more claim forms. So you may obtain a consultation from any physician, and the employer or the insurance company is obligated to pay for those as long as they're necessary, as long as they're reasonable and necessary. Okay, back to Section 32C of the QME regulations, or now Section 32D. When an agreed panel QME or a QME determines that a consultation is necessary pursuant to this section, and the physician selected for the consultation is not selected by the parties from a QME panel issued by the medical director, the referring QME, which is you, the referring QME must arrange the consultation appointment and advise the injured employee and the claims administrator and each party's attorney, if any, in writing of the appointment date, time, and place by use of QME Form 110, also known as the QME Appointment Notification Form. And so it's incumbent upon you, doctor, if you feel that a consultation is necessary you can order that. You can order that immediately after your evaluation of the injured worker. You can order it after the deposition. And when you do order it, you are to make all the arrangements. You are to schedule the appointment with the specialist. You are to arrange the day, date, and time that's convenient for both the injured worker and the specialist. And you are to notify all parties, including the injured worker, the claims administrator, the attorney, the applicant attorney, the defense attorney, and also the consulting specialist. You're to notify all parties by use of the appointment notification form. Then, once a consultation has been made and the appointment has been kept, the consulting physician shall serve the consulting report on the referring QME. Upon receipt of the consulting physician's report, the referring evaluator, and that's you doctors, the referring evaluator shall review the consulting physician's report, shall incorporate that report by reference into the referring evaluator's medical legal report, and shall comment on the consulting physician's findings and conclusions in the discussion section of the evaluator's report, in the discussion section of your report. So the injured worker has now gone for their consultation appointment. The consulting doctor has rendered his report. He renders that report directly to you. You are then to incorporate the findings and conclusions of his report into your own report. Incorporate those opinions and conclusions into your report. Now, that's the way it's supposed to happen. That you get the consulting physician's report within time before your report is due, which is what, doctors? 30 days, correct? So, in an ideal world, you will get the report with sufficient time for you to then comment and incorporate the consulting physician's report into your report. However, in the real world, this rarely happens due to delays and timelines and busy schedules and difficulties and challenges. It would be extremely rare, in my experience, to have your injured worker, first of all, see you. Let's say the injured worker sees you on March 1st. It would be extremely rare for the injured worker to see you on March 1st, see a consulting physician sometime in March, and have the consulting physician get his report back to you sometime in March, in time for you to get your report out prior to April 1st. Or, I don't know, March 31st. How many days in March? Anyway, within 30 days. That would be extremely rare due to busy schedules and scheduling hassles. More commonly, the consulting appointment will come after you issue your QME report, and then the consulting physician's report will come to you, and later on you will issue a supplemental report incorporating those findings now into the conclusions of your prior submitted report. And this procedure is described in Section F. Again, we're in Section 32 of the QME regulations. Subsection F says the referring QME shall file the comprehensive medical legal report within the time period, which is what? 30 days, right? Within the time period specified in Section 38 of Title 8 of the CCR. Okay, so it's 30 days. So you still have to get your report in 30 days. In the event a consulting physician's report has not been received or will not be received, and that's generally going to be the case, right? The report has not been received or will not be received in time to comply with the time periods, the referring QME shall serve his comprehensive medical legal report timely, and upon receipt of the consulting physician's report, the referring evaluator shall, within 15 calendar days of receipt of the consulting report, issue a supplemental report that incorporates the consulting physician's report by reference and comments on whether and how the findings in the consulting report change the referring evaluator's opinions. So it might be whether. I mean, you might not change your opinions at all, or you might, in which case you explain whether your opinion changes and how your opinion does change as a result of information coming to you from the consulting physician. So this is more likely the procedure that you're going to follow. That you'll first issue your report, you will then make the referral to a consulting specialist, and then later on you will issue a supplemental report. If the referral for a consultation takes place after the deposition, then you'll simply write a supplemental report when you receive the consulting physician's report. Reason number 6 why an applicant attorney would request a deposition with a doctor is to determine whether a re-examination might be required. And there's a number of reasons why a re-examination might be required. For example, it may be that the last time you saw the injured worker was, 6 months ago or 8 months ago, in which case maybe range of motion findings would be obsolete, and you would need to remeasure range of motion findings, etc. Reason number 7 is that applicant attorney might request a more specific comment regarding the applicant's eligibility for job displacement benefits. Reason number 8 that an applicant attorney might request a deposition is to establish the mechanism of injury, and in the case of an applicant attorney, to establish that the mechanism of injury was more severe than it otherwise appeared. Right? And we could say the opposite too on the defense attorney side. We didn't list this as a reason, but it makes sense that the applicant attorney is going to want to establish the mechanism of injury to be more severe than it appears, and the defense attorney is going to try to attempt to make the mechanism of injury appear to be more minimal than it appears. Because, as we'll discuss later on in our case examples, the mechanism of injury is directly related to the apportionment determination, and you'll find this discussed at length in the Escobedo case, which I've included in your references. The mechanism of injury. Reason number 9 that an applicant attorney may request a deposition with a doctor in the case of a favorable QME report is to establish that the conclusions of the QME qualify as substantial medical evidence. In other words, to lend support to the doctor's opinion by proactively demonstrating how the doctor's report actually is substantial medical evidence. In other words, the applicant attorney can proactively demonstrate this rather than have the parties search the report over and see, okay, is this based on relevant fact? Is this based on clearly stated reasoning, etc.? The applicant attorney might choose to go ahead and just illustrate the examples of why and how the report qualifies as substantial medical evidence. And I run into this quite often. Let me give you some examples, which I'll give you in just a minute. Further, with regards to substantial medical evidence, we talked about how substantial medical evidence is described in the Escobedo case. Our other reference describing what constitutes substantial medical evidence is found in the Yeager construction case, also known as the Gatton case. And I've given that case to you in your handout materials. You'll need to read that case in its entirety because several of the exam questions come from the Gatton case. And the conclusion of the Gatton court regarding substantial evidence was as follows. Quote, to constitute substantial medical evidence regarding apportionment, a medical opinion should, number one, disclose the physician's familiarity with the concepts of apportionment. Number two, should describe in detail the nature of the apportionable disability. We talked a little bit about that before with the example of the shoulder and the resection of the distal clavicle. And number three, should set forth the basis for the physician's opinion so that the board can determine whether he or she is apportioning under correct legal principles. Interesting. So our definition of substantial medical evidence grows. According to the Gatton case, you must demonstrate that you have familiarity with the concepts of apportionment. How would you do that? You would do that by quoting Labor Codes 4663, Labor Code 4664, quoting Escobedo case, quoting Yeager case. In other words, you must demonstrate your familiarity with important concepts relating to apportionment. Number two, you should describe in detail the nature of the disability. And number three, you must set forth your basis for your opinion. How do you do that? By explaining how and why for every opinion that you submit, every conclusion that you arrive at has to be explained with the how and why, so that the board can determine whether or not you're using correct principles. And as I said, you come across this quite a bit in depositions. When you render, for example, a favorable applicant report, the applicant attorney is going to want to illustrate or highlight how your report is substantial so that your apportionment determination will hold up. So it'll be described as valid apportionment versus invalid apportionment. And I went through a couple of my deposition transcripts to pull out examples, and here is a series of questions from an actual deposition wherein the applicant attorney is simply trying to establish my opinion as substantial medical evidence. And he does this unbeknownst to me. Yeah, I didn't know that this line of questioning was going to come up or go along this way. I simply realized this in retrospect after reviewing the deposition transcript, and I realized, oh, he's establishing my report here as substantial medical evidence. Isn't that amazing? And then the very next time that I came across this line of questioning, I knew what was happening, and I went with it. So, for example, here's some actual deposition questions. Number one, you had an opportunity to review Mr. Jones's medical records. Is that correct? Correct. What's the purpose of that question? That question is based on the fact that substantial medical evidence requires that your opinions be based on relevant facts. Medical records are relevant facts. The question is, you had an opportunity to review Mr. Jones' medical records. Is that correct? In other words, you have all the relevant facts regarding Mr. Jones from his records. Is that correct? Yes. Question number two. And you had an opportunity to examine Mr. Jones yourself. Is that correct? Yes. Yes, my opinion is based on relevant facts. It's based on the fact that I actually put my hands on and spent face-to-face time with Mr. Jones, and therefore I am in the best position to be able to tell you what percentage of permanent impairment is due to this and what percent is that. In other words, my opinion is substantial because I and I alone had the opportunity to personally examine Mr. Jones. Next question. And you also took a history directly from Mr. Jones. Is that correct? Yes, correct. In other words, your opinion is based on relevant fact. The relevant fact that you personally read the records, you personally examined Mr. Jones with your own hands and your own eyes, and you personally took the history directly from Mr. Jones yourself. And you can imagine all kinds of other questions, the purpose of which are to substantiate that your opinions qualify as substantial medical evidence. And so, as we leave this section of the report, doctors, I give you in the handout section of your materials, I give you a template, or I give you some language that you can use and you can import into your report to demonstrate that your report does qualify as substantial medical evidence. And this is language that I put in every one of my reports, or I should say every one of my reports that contain an opinion on permanent impairment and apportionment. You wouldn't put this in a report where the injured worker is not yet permanent and stationary. But where you're offering opinions on permanent impairment and apportionment, you can use this language, and this language is so valuable. And this template is so valuable. It's so valuable for two reasons, which I'll explain as we go. So let's go over this language. And I put this in my report right after my causation and apportionment section of my report. So in my reports, I discuss permanent impairment, and then after the permanent impairment percentage, whole person impairment percentage is established, I then go into the causation of the permanent impairment and the apportionment of the permanent impairment, and then I render all my opinions in that section, and then following that I insert this language, and it starts as a new heading, not in bold like permanent impairment is in bold, and causation and apportionment of the permanent impairment. That's bold topic headings. This I put in all capitals but not bold, and that sort of indicates that it follows underneath the causation and apportionment heading rather than a brand new different topic heading. For example, future medical care would be a bold all capitals heading. I just make this all capitals. So it says in all capitals, substantial medical evidence. Drop down 2 lines, and the following language says, the above opinions on permanent impairment and causation/apportionment of the permanent impairment are based on : and then you list what it's based on to indicate that your report is substantial medical evidence. Number 1 is based on reasonable medical probability and my professional experience. Number 2, it's based on an adequate history as provided in the medical records and as clarified by Mr. Jones. Number 3, it's based on my physical examination of Mr. Jones, and if you've examined Mr. Jones more than once, you would put the dates in parentheses, as the qualified medical evaluator. So let's restate that. It's based on my physical examination of Mr. Jones as the qualified medical evaluator. And if you've seen Mr. Jones 3 times, you would put the dates in parentheses. And that is so powerful because it indicates that it just makes your report all that much more substantial and your opinion all that much more substantial. Whose opinion is going to be more substantial than yours? Heck, you've seen the guy twice, 3 times, 4 times. Okay, number 4. My opinion is based on a review of the available diagnostic studies, comma, medical research into the findings of the diagnostic studies, if there are any, doctors. If you come up with some unusual findings in diagnostic studies and you have to research that, here is where you can document that that research supported your apportionment determination, comma, and follow-up consultation with blank MD or DC or DO or any other specialist that you followed up with. And what I'll frequently do is if I order out for diagnostic studies, for example MRI studies or CT studies or X-ray studies or electrodiagnostic studies, and those studies come back with any unusual or unexpected or significant findings, I'll call up the doctor and I'll have a consultation with him so that I can understand the significance of those findings. So if I do that, I document that here, that consultation factored into my apportionment determination. Finally, number 5, my opinions on permanent impairment and apportionment is based on reasonable medical probability and does not rely on speculation or conjecture. Key phrase, does not rely on speculation or conjecture. So doctors, review this language, look at it carefully, and this is so valuable. The reason it's valuable is twofold. Number 1, it serves as a checklist for you as you read each one of those support statements, those statements that support your opinions. Make sure that your report actually substantiates those statements. Don't just put those statements down if they're not true, but make sure that your report does comply with each of those statements. Make sure that you actually did and can document that you took an adequate history. Make sure that you did and can document that you thoroughly reviewed the medical records. Make sure if you cite diagnostic studies here, make sure it's some other section of your report that you further reference those diagnostic studies and those findings. And make sure that nowhere in your report are you speculating or relying on conjecture. So if you go down this check sheet and make sure that your report complies with each of its terms, you'll be in great shape. It's also extremely valuable for the other parties. For example, if you write a report that's applicant oriented and it's substantial, meaning it qualifies as substantial medical evidence, the defense attorney is going to go down this checklist and he's going to run out of counterpoints or points upon which he can challenge you, because he can see clearly that most of your opinions or all of your opinions and conclusions are supported and are substantial. Similarly, the applicant attorney is going to look at the report and go, wow, this is a solid report. And doctors, this is one of the components of the reports that really makes it solid, that makes it internally consistent. So I can't recommend it enough, and it's so important, especially since Escobedo and the Gatton cases came down. So I give it to you, use it, and make sure you read it, or read the Escobedo and Gatton cases, and you'll see that this is a brilliant extraction from both of those cases that you can put into your reports with your very next report. And finally, reason number 10 why an applicant attorney would request a deposition is to establish the credibility of the applicant. And you can imagine this. An applicant attorney is there representing an injured worker, and with all the crazy cases that we see and all the stories that we've heard, a lot of decisions come down simply to credibility. And this is one of the primary strategies of the applicant attorney, is to establish their client's credibility. And they may do that by asking you to reiterate the injured worker's work history. For example, if Mr. Jones has worked for 25 years at the same company with no industrial injury or complaints or discipline, that would establish applicant credibility. If the injured worker provides a credible exam, in other words, doesn't have non-physiologic exam findings, has negative Waddell signs, and gives good effort on the physical exam, the applicant attorney might want to emphasize that point, and a deposition is a perfect opportunity to do that.